Hello YouTube, my name is Eric Skidmore and I'm an attorney in Akron, Ohio. I'm creating a series of podcasts about the significance of the phrase duration of the marriage in Ohio divorce law. The concept of duration of the marriage is used in many ways in divorce cases, such as determining the length of spouse support, identifying marital and premarital assets, and setting valuation dates for marital assets. Establishing a beginning date and ending date of a marriage is key in determining the economics of a divorce case. Most of the attention in divorce cases focus upon the termination date, which I'll cover in future podcasts. For now, let's go back to the start of marriage and take a look at the issue of when do marriages begin for divorce purposes. Alright, so going back to the beginning of marriage and determining when it starts is pretty easy because traditionally it's the ceremonial date. I've taken the wedding vows here in traditional Catholic vows in establishing the ceremonial date, taking a look at it because it's got some legal significance. You know, so for example, when you recite your wedding vows and it says, "I take you to be my lawful wedded husband and wife," I mean, that is a present intent to be married, and that is really important in establishing marriage. And at the same time, that present intent is almost required to enter into any kind of contract, let alone a marriage contract. When the vow says from this day forward, it also projects that present intent to be bound in marriage. So I just highlight that because in the law, that present intent is also in contractual relationships, and in some instances they look at marriage as being a civil contract. The definition of marriage, just the basic legal definition, is the legal union of couples as spouses. The basic elements of marriage are that both parties legally are capable of contracting to marry and that there's a mutual agreement. And again, I highlight this terminology because legally capable, again, goes to state of mind of solidifying the marital contract. You have you're contracting to become husband and wife, and that you have this mutual agreement. It can't be a unilateral agreement where one person has the intent to marry. It needs to be mutual, and both individuals need to have the intent, the present intent to marry. A common law marriage, that is different than a ceremonial marriage, and that would be a different date in which to begin the duration of the marriage or to begin the marriage. The general definition of common law marriage is a marriage that takes legal effect without ceremony when two people capable of marrying live together as husband and wife, intend to be married, and hold themselves out to others as a married couple. I highlight again terminology. This is common law marriage is without a ceremony. Two people are again capable of marrying. That means they have to have the state of mind. They live together, which is the cohabitation aspect of it. They have to have the present intent to be married, and they hold themselves out to be a couple. Those are the types of things that you need to establish a common law marriage in certain circumstances. All right. States recognizing common law marriage, there are 9 states, including the District of Columbia. Out of those 9 states, Ohio has prohibited common law marriage, so Ohio is not a part of that list. What about Ohio and common law marriage? Well, in Ohio Revised Code section 3105.12, it prohibits common law marriage. And the statute specifically provides that on and after October 10, 1991, common law marriages are prohibited in this state, and the marriage of a man and a woman may only occur basically informal ceremonies. However, the statute goes ahead and continues, and it protects common law marriage that exists before the effective date of the statute, and it also protects common law marriages entered into in other states where people are seeking a divorce in the state of Ohio. So Ohio, for the most part, has prohibited common law marriage, but it has grandfathered in some terminology so that common law marriage can exist. It just has to exist before 1991. There is a controversial debate about the fact that Ohio has prohibited common law marriage. The issue is prohibiting common law marriage is a way of forcing people to conform to a way we want them to behave, not as they actually behave. And so there's some criticism of the fact that common law marriage has been prohibited because you could have a lifetime helping mate that has no legal rights or is a legal stranger to the division of property rights. And some people basically say, listen, the prohibition against common law marriage is archaic and outmoded, and that's the controversial debate.